Hello, everyone. Welcome to Court with Krissy. I can think of more than a million reasons why this defendant wouldn't want to show up for his sentencing. Glad he got the county Uber to pick him up. Should have hit his head just a little bit harder. This former funeral director embezzled more than $1 million. I've included a few articles in the description. This is his sentencing. I hope you like it. Court with Krissy is now in session.
This is file number 267390 at H, time and date set for sentencing. Appearing on behalf of the defendant is Elizabeth V. Weisenbach. And from the Attorney General's office, sir, could we have your name for the record?
Michael Trescone, Your Honor.
Please spell your last name, sir.
Trescone.
Thank you, Mr. Trescone. This is time and date set for sentencing for the defendant in this matter. Ms. Weisenbach, where's your client?
Thank you, Your Honor. My client is not with me at this point. I received a call and I have since received a text message from his wife that he is at the hospital.
Mr. Trescone, do you have any response?
Your Honor, the people tried to meet with Mr. Kaufman before the case was filed in an attempt to resolve this pre-charge. Every time we set up a meeting with Mr. Kaufman, he canceled the meeting the morning of because he was in the hospital. This seems to be the game that he plays to avoid responsibility, and the people are requesting a bench warrant.
Ms. Weisenbach, any response?
I have no reason to disbelieve his wife. There is nothing in this record or any reason whatsoever to doubt her truthfulness with regards to the matter. If that's where he is, that's where he is.
All right. Well, for the record, we did have a brief conversation off the record regarding this matter. The court was advised that the defendant is unavailable, and at least at this point. And the Attorney General's office has placed on the record exactly what was stated during our conversation. And as a result of that, this matter is scheduled for 9 a.m. The defendant is not here. He has until 9:30 this morning to appear. If he fails to appear in this matter, the court is going to issue a bench warrant for his arrest, body bond. And that was discussed as well in chambers as well, Ms. Weisenbach.
I just want to let the court know that is agreed. I want to let the court know that I could probably be available until 11 o'clock. I have 2 other matters, and I do need to meet with an individual whom I am substituting for different attorneys, so that would take some time. So I can be here until 11 o'clock.
All right.
And Your Honor, if I may, if the court would provide a paper copy of the warrant at 9:30, I have my special agent here in person who plans to go directly and arrest Mr. Kaufman.
Very well. We'll try to get that done as quickly as possible.
Thank you.
We'll adjourn, I should say we'll go off the record and we'll recall this case around 9:30 or so.
Thank you.
Thank you, Your Honor.
State of Michigan versus Terry Alvin Kaufman, file number 267390 FH, time and date set for the defendant's sentencing. Mr. Kaufman is in the courtroom represented by Attorney Elizabeth V. Weisenbach. On behalf of the Attorney General's office is Attorney Michael Trescone. The defendant, by way of history, on March 16th of this year, pled no contest to 1 count of criminal enterprise, 2 counts of embezzlement, $20,000 to $50,000, 5 counts of embezzlement, $1,000 to $20,000, and funeral contract conversion, 31 counts. A pre-sentence report has been prepared by Ms. Karen Everland, dated April 21, 2026. A number of letters have been submitted to the court. Those letters have been provided by Susan Mergel, MERGL, Judy and Thomas Krager, CREGEUR, Dan and Betty Jo Glaza, Cynthia Phillips, Larry Brown, Marilyn Gilbert, Emily Ginther on behalf of Norman and Shirley Ginther, Lena L-E-N-A Soper, the Public Guardian's Office, Jacqueline Braun, Kenneth Clement, Betty Lou Burkhardt, Mary L. Gilbert, Gary and Wendy Ayotte, A-Y-O-T-T-E, Ted and Carol Polk, Cynthia Rutkowski, Wayne and Lila Mae Clemmer, Raymond Gentner, I believe it's Luke Martin, I couldn't read the signature, as well as Helen, Donna, and Dennis Storable. There were other letters that were kind of chopped off a little bit. The court could not get the names, but the court did review all the letters that at least placed on the record the court has submitted. Ms. Weisenbach, have you and your client had the opportunity to review the pre-sentence report?
We have, Your Honor.
Are there any additions, deletions, corrections, or objections?
Thank you, Your Honor. In my meeting with my client, we had discussed the phone number that was listed on this, and I was in contact with Michigan Department of Corrections. That is his wife's phone number. He did not have a phone after this had started, so I asked for that number to be stricken. It is her number. It is not his. It should not continue in this record, and I appreciate they have updated and we have received that.
All right, anything else?
Yes, also I direct the court to page 6. There are 5 paragraphs that conclude the section entitled Description of Offense Narrative. That begins on page 3. On page 6, there are 3 paragraphs. The second paragraph, the 4th paragraph, and the 5th paragraph are all ancillary information, not part of this investigation, unsubstantiated. Basically started off with gossip and rumors. They chased that around, and I think it's inappropriate to include that. It's not part of these charges. It is not part of this true investigation. And as a result, I asked the court to strike it. Your Honor, you do strike things that are not charged, cases that are dismissed, factual information. We just did it a couple of weeks ago. I would ask you to strike these 3 paragraphs and to not have any consideration towards there is sufficient information for this record in order to consider your sentencing today. I would ask you to strike those 3 paragraphs. They just should be part of this record.
Mr. Tresco, your response, sir.
Your Honor, this case was charged. As a result of this case, numerous other victims came forward and we continued investigating essentially where all the money had gone. So I understand Ms. Weisenbach's argument in that Mr. Kaufman is being sentenced today for stealing $192,000, although much, much more was stolen. The information contained in those reports and contained in the ongoing investigation is germane to what became of that money. And we believe, regardless of the amount that Mr. Kaufman spent on lottery tickets, whether it be $192,000 or $1.1 million, I believe it's important for the court to know essentially what his scheme was funding, which was his addiction to lottery tickets.
Ms. Weisenbach, final comment, please.
It's inappropriate. It doesn't belong in the PSI. We do not ever chase where the money went. We do not chase that when we consider larceny cases. We do not consider it in other types of cases. So restitution, et cetera. Restitution has been handled and agreed upon. Victims have been listed and agreed upon. It's irrelevant, and I think it's inappropriate before this court.
Any comments from the probation office?
Your Honor, that information was obtained from the report, and that was why it was included in the PSI.
Thank you. Well, the court has heard the respective objections by Ms. Weisenbach on behalf of the client and the response by the people, as well as hearing the comments from the probation agent. Frankly speaking, there's no doubt that restitution has been agreed to, the amounts that is, but relative to where the money was or went, I think is important to understanding what efforts the court would have in getting the money back. So I think it's very relevant. Objection is respectfully denied, Ms. Weisenbach.
Thank you, Your
Anything
Honor.
else for the record?
Now with regards to PSI,
Okay. And guidelines are finalized, correct?
yes.
Mr. Tresco, any objection to the report as well as guidelines?
Your Honor, I believe based on Mr. Kaufman's behavior this morning, that OB-19 should now be scored at 10 points. The OB-19 is not offense specific. Any behavior occurring up to sentencing can be scored under OB-19, and I believe that failing to appear for a sentencing hearing counts as 10 points for otherwise interfering with the administration of justice.
Ms. Weisenbach.
Thank you, Your Honor. This morning at approximately 8:18 a.m., just a little under an hour before we were to proceed with court, I received a phone call from Mrs. Kaufman that her husband had an injury and she was taking him to the ER. We had a brief conversation with regards to that. I asked her to keep me posted of his whereabouts. And I have paperwork in front of me that he was at McLaren Regional Hospital. I'm letting the court know, and I can present this to Your Honor, that he had suffered a concussion. I have this in front of me. He now is sitting in front of you with a concussion, having suffered this morning. There was no, as far as I can tell, except for comments made by the Attorney General that are out of the record for anything else except just today.
There is no information that I have that my client has attempted to not be in court. He has been at every court hearing. He has been at every meeting that I have asked him for. He has met with the investigators. He gave statements. They are in the PSI. And to say today that he was dodging today, his wife called me and said, this is what happened, what to do. And I told her to take him to the hospital. That is where he was. I have yet to give any disparaging comments to this court to mislead this court or anything to that effect. And my client has told, his wife has told me where he is. We've known where he is. He went from home to a hospital and now he's here. I would ask the court to disregard any request made today with regards to PSI, I'm sorry, with regards to sentencing guidelines. And they were due a week ago or more. So I understand the position is that somehow it's an emergency to them today. It's not. He was in the hospital and I can approach with this documentation.
That's final alert.
Your Honor, regardless of whether the reason he was at the hospital, the fact is the court signed a warrant. My special agent went to the hospital to try to arrest Mr. Kaufman. Mr. Kaufman had already been discharged and had gone home. Had Mr. Kaufman been discharged and come to this court, I might not be making this argument, but the fact is he chose to go home and he was arrested at home and brought here in handcuffs.
All right.
And with regard to the time frame, I don't know how I could have possibly made this argument a week ago since that it happened 2 hours ago.
Also at 9:35, his wife stated that he was discharged. She sent me a screenshot of the paperwork and I texted her back that you have to bring him to court. Judge had issued a bench warrant. So all of this was going on at the same time. I had told her to bring him here, but moments later, then she said, okay, 10 minutes later at 9:55, she said that the sheriff and a prosecutor came and picked him up and they're leaving. So no one's been dodging anything or avoiding anything. His wife has been in contact with me. He was having a concussion. He wasn't in a position to make any specific actions with regards to his behaviors today. She took him to the hospital. She was going to bring him here. They just got there first. That's the only difference. She has been very compliant, very appropriate this whole time. There's nothing to be held against her.
Well, she's not the one before the court, her husband is.
Understood, but I want you to be aware of who I was communicating with this morning. My client was in no position to communicate with me.
Sentencing guidelines can be considered up until the time of sentencing. Obviously, if there's an objection relative to what probation department had scored, then certainly that's why the timeline is there. But certainly circumstances can arise where, for instance, OV-19 may be in play that the court would consider. But based upon all the circumstances, the court is going to continue with sentencing with the original guidelines for OV-19 respectfully is denied relative to 10 points. Any other objections to the reporter guidelines?
No, Your Honor.
Ms. Weisenbach, is there anything you'd like to say on behalf of your client before the court imposes sentence?
I believe that at this point, I am required to ask this court to consider an adjournment in light of the fact that my client is sitting here with a concussion that is medically documented. I can approach the court with this documentation.
Show it to Mr. Tresville first. That's going to give the opportunity to review the document.
I have, Your Honor.
Your position, sir.
Your Honor, I don't see what the point of an adjournment is at this point. Mr. Kaufman has admitted his crimes. He's here to be sentenced today. He'll get excellent medical care in the Department of Corrections.
I would like to present the materials.
Thank you, Your Honor.
Is this the discharge documentation?
That's my understanding, yes. That's what he was sent home with.
There's no indication the alleged fall occurred. Nothing.
That's what I did.
Is there anything in the medical documentation to indicate that the defendant is unable to understand what's going on? The head injury, alleged head injury is traumatic enough where he wouldn't appreciate what's going on today?
That's inherent in having a concussion. That's what a concussion is.
Your Honor, I strongly disagree. And I believe that Mr. Kaufman, Ms. Weisenbach can voir dire her client if that is in fact the case, but I would ask the court to also take testimony of the client that he does not understand what's going on today before the court considers an adjournment.
Raise your right hand, sir.
You solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God.
Yes. Ms. Weisenbach.
Can you hear well enough?
Yeah.
Okay, all right. Um, Jerry called me this morning, right? Your wife,
Yes,
and you were aware that she called me?
yes,
Okay. You supposedly had a fall this morning and then she was taking you to the hospital, correct?
yes,
Where did you go to the hospital?
here in Bad Egg.
And what's the name of this hospital? Okay, how long were you there? Do you recall who you had seen as medical treatment people?
I don't know their names.
Just kind of give me like what happened at the hospital.
They hooked me up to things. And then they did a CT scan.
Okay. Describe what happens during a CT scan.
You lay on your back and they put you into a tube. And I'm assuming the camera goes over you.
Okay. Was it just your head then?
Yes.
So you had a head injury?
Well, he said I have a hematoma in the back of my head.
Okay. Are you able to hear and understand everything that's happened today?
Yes.
Do you feel that the injury to your head has caused you any issues with regards to understanding the judge?
No.
Okay. I have nothing further, Your Honor.
Any questions?
Don't see any basis to grant an adjournment.
Based upon the sworn testimony, the defendant understands what is proceeding, or what the proceeding is all about. On his own sworn testimony, we will see the sentencing right now. Weisbach, I'll tender that back to you.
Thank you.
I'll hand you this as well. Is there anything you'd like to say on behalf of your client before the court imposes a sentence?
Thank you, Your Honor. Yes. I met with my client last week to review the PSI. Also available were the victim letters. I want this court and I want everyone to understand I read every single letter. I read every single letter, every heartfelt thought, everything that was in there. I understand their position. With all due respect to the victims, my comments are never meant to be disrespectful. But there are two sides, and today is the side of Terry Kaufman. He comes before this court, 72 years old, actually no criminal record, married, 3 children, high school diploma, advanced education, and just about 50 years of providing compassionate funeral service for many, many grieving families over many years. Kind, considerate, soft-spoken, polite, respectful, and for yes, many years, well-respected citizen businessman. In these letters, I know you've read them too. There are stories of kindness, seeing that he had gone above and beyond what was necessary in his advanced years, shoveling out a driveway just so that a funeral could take place. As he had stated in his comments during the investigation, this money was not sent into the escrow. It was used to put back into the business, especially payroll. There were other people on the payroll, other employees. Yes, he was an employee. There were slow times. There were lean years, and the doors could have closed. The doors were kept open because of that cycle of money coming in. It's not a secret that funeral business has been changing. They are struggling. There has been, in my area where I live, a murder, Elkton, Caseville, Pigeon, Cass City. And I tried to look it up this morning, but I think that Seaboyne has had to merge as well. Coffins would have closed many years ago if it hadn't been for this particular income. Provided this service all these years for these families. During this time, he was not living extravagantly. There's a lot of people who know him, who know how he lived. There are a lot of people who don't. There are, have been made comments outside of this court with regards to living an extravagant life. He lives in a modest ranch house, and the court has seen in the PSI there's still a mortgage. And in return for living modestly and keeping a business open, those who had passed were given their funerals. It didn't matter if it was at that funeral home or if it was at a different one. The money went to wherever the funeral was held. And this actually happened in the case that triggered this situation. The money was always sent and it was covered. Credit was given, and he honored the word to the people who he had told them that it would be okay. And he always expected and planned on honoring that. I could not ask for a better client when it came to appropriateness towards me. He has been polite, respectful, kind, generous, and compassionate. He understood my position. He understood the role I served. He was always appropriate, always on time, always came to the meetings I asked for. As you can read in the PSI, he is resigned and accepting of what is going to happen. He is aware, and he is fully prepared to accept the sentence from your honor. With that being said, again, I'd like to remind everyone, there's two sides. There was a business that kept going for the people of this community. It was not exactly the way it was supposed to be. I get that. So does he. There's just always two sides. And I appreciate your honor and everyone's understanding of that. Thank you.
Does your client wish to address the court in light of the no contest?
Also, in light of the lawsuit that has been filed, no.
Very well.
Thank you, your honor.
Mr. Tresco, anything on behalf of the people, and this is a victim's rights case.
Yes, Your Honor. Before I make my argument, I would like Ms. Braun to address the court on behalf of her wards, the 55 victims named.
State your name for the record. You can stay right there.
My name is Jacqueline Braun. I'm the Huron County Public Guardian.
You may see what would you like to tell the court.
Your Honor, I represent 55 people who have been taken advantage of by Mr. Kaufman. These people are either illegally incapacitated or developmentally disabled without the ability to care for themselves. Some of them do not have the ability to understand what has happened to them. These people do not have much. The little they do have is carefully budgeted and spent so that they may live comfortably, and so they are cared for. The money in the prepaid burials was mostly supplemented by the stipends sent out during COVID. That money was carefully done. That money will never be replaced. Some of these individuals will never have anything extra to pay for a burial or put into another prepaid again. That is why the careful planning was done. That is all for nothing now. All of that planning is gone. I ask you to take into consideration the impact that will have on these people that do not have the ability to care for themselves or understand what happened here, as well as take into consideration what has happened to the rest of the victims in this case. Thank you.
Thank you. Let's go. Any other?
No other witnesses, Your Honor, this argument.
You may proceed.
Your Honor, Mr. Kaufman argues for leniency based on his lack of criminal activity. Mr. Kaufman admitted to 39 felonies, including criminal enterprise with predicates spanning the last 10 years. So it's not for lack of trying that Mr. Kaufman has no criminal record. It's simply that it took a while for him to get caught. He argues for leniency based on being a respected member of the community, but the fact is he abused that respect in his position in this community to steal from the members of this community. He claims he did this to keep the business afloat, but his bank account records showed that he paid himself $1.5 million in the last 10 years. That wasn't money kept in the business. That was money that was moved to his accounts, including secret bank accounts his wife didn't know about.
Your Honor, I'm going to object. None of this is in the record. And I would also like to point out that as of yet, my client has not asked for any leniency, but in fact was ready to plead 3 or 4 proceedings back, but the Attorney General's office wasn't prepared. My client wants this record to be clear. He never wanted to ever come before this court and say not guilty. He never wanted a trial, and he hasn't asked for leniency. I would ask that the pre-prepared speech that's maybe cookie cut for every other case be tailored to exactly what's going on today. My client did not ask for leniency. My client isn't dodging coming to court. And anything extraneous that's not inside this record, I think is inappropriate with regards to it being arguments, PSI, whatever. Thank you.
Noted for the record. May proceed.
Thank you, Your Honor. He also claims that, again, if someone came to him for a funeral, even though the money wasn't escrowed, even though the money was gone, he still did the funeral. And of course he did, because the minute he misses a funeral, the jig is up and he's caught. And that's what happened. Somebody else went to have a funeral at a different funeral home, and that funeral home found out the money was gone. And that's how this all came to light. Your Honor, the sentencing guidelines do not address the level of criminality that Mr. Kaufman engaged in. He scored 25 points on OB9 for having 20 victims. He had 55 victims. He scored 5 points on OB13 for 3 or more property crimes. He admitted to 38 property crimes. And he scored 10 points on OB16 for a loss of $20,000 or more. The loss was over $192,000. Based on all that, the people are asking the court to, at a minimum, sentence Mr. Kaufman to the top of his guidelines, with count 1 running consecutively to counts 2 through 8 for a total sentence of 108 months or 9 years. Thank you.
You're welcome. These are not easy cases. Court notes the number of individuals in the courtroom. I respect each and every one of you for being here. I respect any support that Mr. Kaufman may have received from family or friends as well here in the courtroom, because the court has to be right down the middle. And the court is going to be right down the middle, because at the end of the day, what may be investigated may be different than maybe what have been pled to, but regardless, we have a significant amount of activity that affected a lot of people. And a lot, I mean, a lot of people. A lot of people that put their faith and trust in this individual. And I couldn't imagine, considering my parents or anyone's parents or anyone planning for their future, because we all know when the good Lord says that's the day, that's the day. And the last thing we want to do is task our children or our other family members to, or friends to get through that. And that's why a lot of these individuals that appear before the court as victims planned for that. And they scrimped and scraped and used whatever they had to make sure that it made it easier for the family upon the death of the individual. And so just looking at some of these letters, for instance, I trusted him, so I wrote a check for $6,691. I'm angry that my prepaid funeral has been stolen. My children are upset that my funeral is now their responsibility. We gave him $15,990. He gave us papers showing that we had paid for both funerals, and we were all set. Both of us are in our 70s and 80s. We have difficulty with degenerative arthritis, walking and memory. Dealing with these issues only makes the stress worse. We trusted Mr. Kaufman as an upstanding member of the community. He assured me that with the funds that I was giving him at the time of my death, the funeral home would arrange everything. All my children would have to do was grieve. I do not understand how a man trusted by his community could so recklessly steal from us. Terry Kaufman took my hard-earned and saved money to use for himself. Due to what Terry Kaufman has done, I feel hurt, angry, betrayed, and humiliated by my trust. I had a pre-need contract taken out in 2016 for $10,000 that was totally gone. I've lost countless hours of sleep worrying about the victims and how they would get justice. That's from a former employee. It's despicable that someone who's a funeral director would take money from elderly sick people and use it for his personal gain. When a loved one dies, it's a very pathetic event. My contract is outstanding and the money is missing. We trusted that $15,000 would be handled with care, honestly, and with respect. The situation has affected us not only financially, but emotionally. It's from a 94-year-old individual. I considered making prepaid funeral arrangements for myself at the time I had the finances and wanted to spare my family from having to endure the burden of experiencing the difficult process. I can still remember a few days later, he delivered the contract to me with a cover letter, and on the envelope he wrote, "You're all set." I felt so many emotions, disbelief, betrayal, anger, and sadness. How could he do such a despicable thing to me and many other people? Now I must face the fact that my prepaid funeral expenses are gone. I will need to start over. The situation has caused our family many sleepless nights and anxiety about how we will bury our father. I have prepaid $10,000 and had the money in the trust of Terry Kaufman that it would be taken care of until my death. Now I have to sit and worry and wonder how are they going to bury me? I don't know if I will ever be able to trust anybody again. I've just been sick over this. I thought I'd be saving my family from having to deal with my funeral expenses. I can enjoy my retirement with peace of mind. I had put trust in him. My stress level has been affecting me every day, my everyday life from this. I've been worried and wondering how my funeral will be taken care of now as the money is gone. We are in our late 70s on a fixed income. Mr. Kaufman assured us that all would be handled properly and professionally. We've never met anyone of this nature before and have no reason to doubt his word. Hurt and disappointed. Beside our payment, we put our trust in him to provide our funerals with a proper end of life, burial, and with dignity. What he really took cannot be replaced, and that was our trust. We should have been able to have our confidence in his relationship with us and in his services. If not him, a professional and a neighbor who shook our hands and welcomed us with open arms, who can we trust? We truly trusted him to provide us with our final farewell. I believed I was dealing with a trustworthy and professional business. I relied on their representations and trusted my money with the expectation that it would properly be safeguarded and used for its intended purpose. I have experienced ongoing emotional distress, worry, and uncertainty. It is extremely upsetting to realize that the plans I made in good faith may no longer be secure. This is not a small amount for me, and my replacing these funds would be difficult. What has been most difficult is the loss of trust. My husband and I have known Terry for years as we have sat across from him at his desk. We respected Terry and looked forward to his help and guidance on my mother's eventual funeral, as well as mine and my husband's and family. We regarded him as a friend, someone to trust, someone to call on in time of need. Always a smile and a handshake or a hug for both. Needless to say, my heart sank and my mind was a jumble, wondering if and how we could get our $21,000 back. Our funerals to ease our burden on family when the time comes, that is, for our funeral. There's no excuses as far as we are concerned. What would happen if the roles were reversed and we had taken his money to gamble it away? We would be held accountable. And the notes continue in that stream. Mr. Kaufman, you were trusted. These people in this room, everyone that's contracted for services that have been affected by this case, put their faith and trust in you. And what happened with the money, it's alleged. I don't know what happened to the money, but when you're talking about restitution of 1.1 million, that's clearly beyond the pale. And that's clearly an issue of trust that will affect these people for the rest of their lives. Simply going into a store, simply going in to hire someone for lawn service, whatever it may be, any meaningful or meaningless task, frankly. These people are going to question that every time. Am I getting scammed? That's what they're thinking. And frankly speaking, there is no jail or prison sentence that's going to give everyone their money back right now. If the court could do that, the court would do it in a heartbeat. but the court's unable to do so. It's based upon the behavior of the defendant in this case. And as a result of that, the court has to consider the guideline range, which is 51 to 85 months at the minimum term. To the defendant's credit, if there's credit to be provided, up until the time the gig was up, individuals were provided their funeral services. That's not the way to run a railroad. Not the way to run a business. We understand that people have difficult times and difficult issues, but when that money is entrusted to people, to a person that it's their end of life decision, that's one of the most important decisions we have to make in our adult lives. And these poor people lost that. And now they have to start over again. Considering the guideline range in this matter, considering the number of charges, convictions that is, 31 just for the funeral contracts, 5 for embezzlement, $1,000 to $20,000, 2 for embezzlement, $20,000 to $50,000, and clearly the criminal enterprise. One could argue that the guideline range may not be sufficient. However, on the flip side, the upper courts, the Court of Appeals, Michigan Supreme Court also looks at the guideline range, which is only considered, the court is to consider the recommendations. But the sentence has to comport with the law, it has to comport with other factors, facts and circumstances, considering the guidelines, and it will be the sentence of this court that first, in count 1, well, actually, let's begin with the embezzlement $1,000, no, back up. Counts 4 through 39. This includes embezzlement, agent trustee, $1,000 or more, but less than $20,000, $5,000, 5 counts of that. And the 31 counts of conversion will be the sentence of this court. And the guideline range is lower for this, but defendant be committed to the Michigan Corrections Commission and placed in the commission's custody for a period of 23 months to maximum of 10 years with credit for 1 day served. Actually, that also covers, back up. I apologize. This pre-sentence report is rather lengthy. The sentence will be 23 months to 5 years with credit for 1 day served. That's the guideline range relative to counts 4 through 39. That's the maximum guideline the court can impose. Counts 2 and 3, embezzlement, agent or trustee, $20,000 to $250,000. It will be the sentence of the court that the defendant be committed to the Michigan Corrections Commission and placed in their custody for a period of 23 months to 10 years with credit for 1 day served. Finally, regarding count 1, criminal enterprise, will be the sentence of this court that the defendant pay restitution in the amount of $1,111,165.77. He's to execute a wage assignment and to pay with that restitution if he's employed and misses 2 regularly scheduled payments. Crime victims assessment of $130 will be ordered. DNA testing fee of $60 will be ordered. State costs total $2,652. Those court costs are due and payable by July 6, 2026, or the 20% interest penalty is imposed. Finally, based upon the number of charges, the number of victims in this case, the amount of money involved, it will be the sentence of this court that the defendant be committed to the Michigan Corrections Commission and placed in their custody for a period of 7 years, 1 month to 20 years, credit for 1 day served, which is again the maximum under the guideline range. The court imposes the maximum based upon what the court already stated. The victims, the amount of money involved, the number of victims, I should state, the money involved as well. It will not provide solace to anyone in this courtroom, it won't provide solace to the defendant, it's not going to provide any relief for anyone. But the court has to impose all its conditions based upon the law. The hope is that the restitution can be recovered and the court will stay diligent in efforts to collect that restitution. But based upon his sentence, it's going to take a large amount of time. I do have to inform the defendant he has right to seek leave to appeal. If he's financially able to provide counsel of his own choice, court will assign counsel for him at public expense. He's to initial the receipt questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the clerk of the court within 42 days. These sentences shall be served concurrently with each other. There was a request for consecutive sentencing. However, based upon the defendant's age and based upon the fact that if there's more time imposed, that gives a lesser opportunity for the defendant to provide funds for the victims in this case. The court is going with a concurrent sentence. Has he executed the document?
Not yet. I think he was listening. He wanted to hear the end of it.
That's fine. That's fine.
A lot of other people just start signing.
That is remanded to custody of the sheriff.